Any mention?
May I please, Your Lordship?
Yes.
I beg to mention item number 7. I pray for 3 weeks time, Your Lordship.
Wait. Item number?
Item number 7, Your Lordship.
My lord, I appear for the respondent state. State is the only respondent here, my lord.
What is the matter about?
It's a service matter, Your Lordship. It's a service matter.
Service matter.
Yes, Your Lordship.
Why are you asking for time?
Due to personal difficulty, Your Lordship.
Whose personal difficulty?
The conducting counsel.
Mr. Sinkon?
Yes, Your Lord.
Yes, madam.
My lord, we have no objection.
This what? Promotion?
No, we have submitted it.
It's not a promotion.
No, sir.
Then what matter it is? Appointment,
What
selection and
happened is, my
appointment.
lord, the petitioner was once employed, my lord. Thereafter, my lord, he had gone for further studies. So it's a lengthy matter, my lord. It's regarding Polytechnic College, my lord.
Okay. Item number 7. On the prayer made by the petitioner, list is met after 2 weeks.
3 weeks, Your Lordship.
Why 3 weeks? Okay, after 3 weeks.
Value of best.
Please, Your Lordship. Your Lordship, I beg to mention item number 15, Your Lordship. If this matter can be taken up after 2 weeks, Your Lordship.
15.
Yes, Your Lordship.
No objection. What is this matter, Shall I? This is service matter again.
No, this is a service matter, equal pay for equal work.
There's many respondents in this matter.
No, only state, Your Lordship,
And
Enjoy municipal.
Okay, it's wait for my learned counsel for the petitioner. This matter after 2 weeks.
Apply, Your Lord.
May I make a mention, my lord, of item 13 of the hearing list, my lord.
Yes.
But here, my lord, what had happened, my lord, inadvertently, my lord, the affidavit was not filed, my lord. The affidavit was not filed, my lord, inadvertently.
Affidavit in opposition.
My lord,
This is 2019 matter, not
my lord.
filed.
My lord, there was some confusion, my lord, because
How
there were
could it
two.
end up in hearing?
My lord, what had happened? There were 2 matters, my lord, which were listed together, tagged together, my lord. One of the matters got disposed, my lord. So that is where the confusion had arisen, my lord. We already took steps, my lord. So if my lord, last occasion also time was granted to us, I am praying for some more
The
time.
last order granted time
My lord,
for filing affidavit.
my lord, that was what I was.
Item 13. I have to check the things.
Make this introduction, my lord. I beg to mention item number 14.
Wait, gentlemen. Yes, on the last occasion, see, the opportunity was given to you for filing
My
affidavit.
lord, kindly allow us, because we have taken fresh steps, my lord.
Okay. The state seeks further 2 weeks time for filing affidavit in opposition. Enlist this matter after 2 weeks.
Obliged.
Yes.
Yeah, please, Your Lordship.
May it please your lordship.
Yes.
Uh,
Yes. Yes, carry
my
on.
lord, I beg to mention item number 14, my lord.
Yes.
My lord, conducting counsel has some personal difficulties, my lord. And
Yeah,
the
for the-
matter may come after 2 weeks, my lord.
You are appearing for petitioner.
My lord.
Are
I
you
am for the petitioner, my lord.
Lordship, I'm for the respondent.
You have any objection? Okay. On the prayer made on behalf of the petitioner, release this matter after 2 weeks. Okay, it will come after 2 weeks.
I'm obliged.
Will your pleasure.
Your Lordship, I beg to mention item number 10. Yes, for?
And for the respondent number 7, Lordship may recollect last occasion we made a short submission. This matter is pending for quite a long time, and without implementing me in the order in their favor. And we proceeded before the learned division bench, and the learned division bench set aside that order and allowed me to become a party here also. And here what happened is, my lord, my issue of appointment as a language teacher was already settled by this honorable court in 2018. Behind my back, another person who is claiming that he is holding the post of social studies, he filed a writ petition and upset my judgment, saying that I'm only a fourth teacher.
Like how? By you obtained that order by suppressing your...
Well, I filed a writ petition in 2017,
Yes.
claiming that I was appointed as a language teacher. The government, my friend and the respondent managing committee opposed that one, that my appointment was wrong. But that matter was the final adjudicated in 2018, that I was properly appointed.
It was decided in your favor.
In my favor, and directed the managing committee and the state government to pay my salaries. Now, behind my back, my friend party has filed a separate petition from the same school, claiming that he is a teacher of social studies. And he claimed that his salaries had been denied to him.
Social studies means claiming is holding the same post. In which?
Different posts. Different posts. Now, he claimed that one. Now, the state government and the managing committee supported his case and said that I'm only a fourth teacher. And some salaries paid to me is wrong. It was supposed to be paid to him. So because of that, my lord, I was implicated as a party. And they have been adjourning one after another. And I have been denied my salary from 2000.
Your Lordship, on the last occasion, conducting counsel was ready. However, it was respondent who paid for time. Your Lordship, the conducting counsel today is out of station. Yes, Your Honor.
Number of order sheet remains. For short remain, your Lordship permits. Tomorrow or next week.
It will be after a week then. After. Okay. On the request of the petitioner, list this matter after a week. Item 10. Highly rich.
But in the meantime, Lordship may seek some indulgence. Item number 2.
Yes.
My lord, 2016 matter. Here the issue involved, my lord, is related to the issue pending in the division bench, where Lordship is one of the members there, regarding the legality of issuance of PATA by the District Council of Karulis.
So here also this question
My
is...
lord, this is really related. So if Lordship permits me, may I pray the matter may come after 4 weeks.
4 weeks.
After 4 weeks. Because the division bench matter is coming in the 3rd week of this month.
District Council is not a party here. No, it is a state. It is against the state.
They are not a party.
So now, wow, what state has to do with regard to Patta and all in Garo Hills?
My lord, they have issued a PATA. And in that PATA, my lord, yes,
has issued.
District Council has issued PATA. In that PATA, they mentioned that 15 feet from the center line of the highway should not be utilized by the landowners.
This is the norms, I think, the normal thing.
Our state claim is that
They
we
claim
have the
from
right of way.
they call it right of ROW, right of way. And they derive this right of way from the Assam
That is
Land
the requirement of
Regulation.
Act. That is requirement by, that requirement is posed by virtue of what? That
Assam Land Regulation. And they adopted. District Council has said that they have adopted the
that is a
Assam Land
question which has been pending before division.
Yes, and we challenge the legality of that act, adoption act. So if Lordship permits, maybe we can come up after 3 or 4 weeks.
Shall we record it? That will be dependent upon the outcome of that. You have a...
It has a connection, direct connection.
Mr. Richel Sangarishan, London Senior Counsel submits that this matter would be dependent upon outcome of a similar matter pending before the division bench of this court. He prays that the matter may be taken up after the disposal of the connected matter by the division bench. We will stop. Accordingly, the matter stands adjourned for 4 weeks.
But similarly, may I bring item number 5, my lord, 2017 matter. I was unable to prepare this matter. If lordship permits me, matter may come up next week. I will inform to my other senior, my friend.
District Council?
We are formal party.
I will inform him in the morning. He's consented. His consent was given.
Yes, all those matters require disposal.
It's all matter, yes. It's all matter.
And ultimately, see what order you can get in this kind of matter from the court. That is also remains a question.
But we will try to pursue.
Limited scope of power of judicial review.
Yes, I'll try to. I'll try my best to pursue, my lord.
The pendency is basically what is. Okay, on the request of the learned counsel for the petitioner, just after 2 weeks. You have no objection, Mr.
I look. Otherwise, throughout the adjourn, my friend adjourned the matter.
My lord, I beg to mention item number 8, my lord. Item number 8, my lord. I'm praying for a week's time, my lord, for some more preparation in the
Now,
matter.
this court sits only for the purpose of adjourning matter.
No, my lord, absolutely not, my lord. Only for little difficulty, I want little accommodation.
Other side?
No objection.
No
Your
objection. You have for the
Lordship, I
petitioner.
have it after 2 weeks.
2 weeks.
Okay, on the request made on behalf of the state, list this matter after 2 weeks.
I'll obey.
May I please, Your Lordship?
Yes.
Item number 11. Item number 11. This is an LSC matter, Your Lordship. My senior, because of Shraddh, he could not come today.
They are saying that the term of the sentence is over, and according to the conviction, my lord, according to the date of imprisonment, if taken into account, my lord, the term period of sentence.
It's a criminal appeal.
Yes, my lord.
Cannot
And
become infructuous. You have to hire it on merit. See, 21, Supreme Court. A similar thing happened. The Bombay High Court closed it. Closed the matter.
So we'll decide
saying
it on
that
merit.
appeal has become infructuous.
here, one more defect is there, my lord, because there was a plea of guilt, my lord. 313 was not adhered to, my lord.
So whether
Although
appeal-
prosecution has
313 was not adhered to means
313 was not conducted, my lord. So, my lord,
there is a plea of guilt. This is conviction on the plea of guilt.
plea of guilt is there, my lord.
Appeal is maintainable.
So, my lord,
Is appeal maintainable under if conviction is made on the plea of guilt?
my lord, we have not argued on that issue on
Whether it is maintainable in law or not, you are not arguing on the decision. Just a question by the court. Anyway, when you this is a conviction on the plea of guilt.
yes, my lord.
The
The
matter
court has recorded because
The
there
matter
was
had
a plea
not-
of guilt. There was a plea of guilt, so 313 was not conducted, my lord. Although the prosecution has examined
if
several
there is a
witnesses.
conviction on the plea of guilt, whether there is a requirement of this thing, recording 313.
Yes, my lord, because the prosecution has conducted all the prosecution evidence, they have
That is not a
recorded.
conviction on plea of guilt. Now, what you are saying, you do not know.
No, that is the
What is plea of guilt?
the plea of guilt if he has admitted.
Anyway, when do you want it?
Next week, Your Lordship. Next week.
Next week?
Yes, Your Lordship.
Okay, item number 11, after a week, on the request made on behalf of the appellant.
Oblige, Your Lordship.
May it please your Lordship. Lordship, I humbly beg to mention item number 4.
Probably the last item in the hearing. Yes.
Your Lordship, the arguing counsel, Mr. JM, thank you. I'm appearing on his behalf. He cannot come today on your Lordship
This
because
matter, perhaps, I think, is repeatedly adjournment has been sought. So if you are not interested, you can close the matter. We'll just close the matter. We'll say that you are not interested.
And for 1, 2, and 3, Lordship. District Council.
What is the matter about?
Not worship, Lordship.
This is with regard to boundary pillars.
And, yes.
There is a boundary dispute between two Akings.
2 Akings, yeah, 2 Akings, 2 numbers.
And this is probably the 6th round of litigation for this court.
Nothing has been settled. Is it not for district council to decide it if there is a dispute between the same?
No, we have decided on.
No, what is the law? What the law says? If there is a dispute, it has to go to district council, isn't it?
Yes, but
This will go before the executive committee or what?
It first goes before the EM, then to the CEM, and then they can challenge.
EM, what is that? EM what?
EM is the executive member of the Land and Revenue.
EM revenue.
Yes.
Then from EM revenue, it will be applicable to
the chief executive member. From there to this honorable court.
So this matter went to this thing EM.
Yes, it went to the
And
EM,
then
CEM.
there
then this
was an
honorable
appeal
court.
before CEM also.
Yes.
Now against that they have come.
Yes. In certain times it was remanded and all.
On many occasions it was remanded back by this court.
The boundary dispute normally in a writ court, what they will do? It will not be possible to determine things exactly.
It's a question of procedure. Yes.
Dorisangma issue that applies to EM or CEM
And that applies to.
or to both. Before the both authority, or if it is enough if one authority.
The letter says only EM. The letter of judgment. Anyway, since there, we have no objection.
That is, see, if you are not interested in doing some matter, say, why should you drag it for so many years? See, like.
30 times, Your Lordship. Just go through the policies.
Okay. Still matters. See, in absence of counsel for the petitioner, also proceed would be quite difficult. Let's see. This will be after 2 weeks on the request made by the list. On the request made by the learning counsel for the petitioner, list this matter after 2 weeks. Item 4.
Obliged. Your Lordship, a similar prayer for item number 6.
Item number 6, you are what? You are?
I'm with the petitioner also.
These are all old matters. 2016, 2007 matters. Yes, Ms. Colney.
My lord, this matter was heard, my lord. I believe Advocate General has also argued this matter in the previous court, and subsequently this matter has come here. And
Before the other bench.
My
Before
lord,
another
yes,
bench.
and then this matter was supposed to be heard afresh. However, the petitioner has been to adjourning
It
this
was
matter.
hard at
since.
some length.
My lord, yes.
But it's not been kept part hard, isn't it?
No, my lord, it has not been kept.
Okay. Again, on the same thing, on the verse after 2 weeks.
Much obliged, Your Lordship.
Please, Lordship.
Any item left? Any item left in the list?
We need to make mention for item 9, Your Lordship. Item 9.
Item 9.
Yes.
Criminal petition for quashing.
Yes, Your Lordship. I'm praying that the matter may come after a week, Lordship. Senior counsel is out of station, Your Lordship.
19 matter. Is FIR quashing of FIR or?
Well, this is an application where they're challenging an order under 216 altering a particular charge from the charges under the Drugs and Cosmetics Act to one under NDPS Act.
Okay.
So they've come before this court under 482 and 397, praying for quashing of that order.
Alteration of charge.
Not
This was done in excess of power under 216.
216.
Then what is the stage of trial now? Is there any
There was an
interim-
initial stay order which was only till 2019, December 2019. After that, they never prayed for any extension of that order.
Then what has happened to the trial?
We'll have to just inquire. I'm not
please
aware at the
inquire.
moment.
Please you inquire.
I'll inquire.
Do not allow this proceeding to be stalled because of this.
Our last communication was that trial can go on because there is no stay order.
please take this.
Oh, sir, I'll take it.
If the matter has proceeded at this stage, why should you interfere?
Lordship,
If
I'll
say,
inquire.
supposing after alteration, and if that matter has proceeded for, say, like for recording of evidence and all those things, if it is done, we will not interfere at this stage. So there is no issue. If they are not diligent in pursuing their thing,
Lordship, I'll inquire.
Anyway, here also on the prayer of the petitioner, let this matter after 2 weeks. The proceeding should not be stalled. See, like
We had informed them this.
Can you please verify this?
I'll inquire. I'll be obliged.
Lordship, I have similar prayer for item 12, Lordship. Lordship, in this matter, I am praying for a short date, Lordship, maybe next week, Lordship.
So what today? Then today, do it today.
Lordship, Senior Counsel.
Court will have enough time today to take it up. You make a mention also as you want short date. How can?
Senior Counsel is outstation.
Oh, that is the same matter. That the matter has basically become infructuous.
Because the newspaper publication was done way back in
So
2019.
how can it be undone? Can it be undone?
How can it be undone, Your Lordship? Because at that, immediately on the publication, they had filed this writ petition. So,
Oh, means they approach the court after the publication was.
yes, Your Lordship. So after the publication, now how can we set aside and,
that prayer-
quash that order of
and that
publication?
prayer is confined to that only.
Only. So they are saying that to issue a writ of mandamus directing the respondents to forthwith withdraw, recall the impugned publication dated 19/6/2019, published by the respondent bank in the local newspaper on 21/6/2019, as to why a writ in the nature of certiorari be not issued, quashing and setting aside the impugned publication dated 19/6. So, Your Lordship, setting aside quashing when it's already in public, and 3-4 years have already gone by, Your Lordship. So the matter, public memory is also short. They must have forgotten, and it's already.
But then the thing is that, say, supposing if any publication is made,
Yes.
what can be done? If it is, say, supposing if it is wrongly done, then later on there can be a clarification with regard to that. Nothing more
But
than
that they have not asked for, Your Lordship.
that is what.
They have only
That is
said for recall of that publication.
So
they have not made any such prayer for.
that prayer after the publication is made. See,
And because he was a willful defaulter,
court
which
cannot
is
issue a futile writ, isn't it? A writ which cannot be executed, that will never be issued.
no, that cannot be done. And the writ petitioner is a willful defaulter. The matter is pending before the before the tribunal.
Things are
It can
uselessly
be
pending.
disposed of as being infructuous, Your Lordship. Then that is why I think parties are also, petitioner is also not interested to take up the matter.
Okay, we can have it next week,
We can have it, Your Lordship.
after a week, on the request of the petitioner.
Obliged.
Obliged.
Lordship, I beg to mention item number 3.
Why?
Lordship, due to some personal difficulty, Lordship.
What person? Mr. Majika was there in the court.
Lordship, he's not keeping well.
He was looking very well in the courtroom.
He has said that, my lord, his backache was there, otherwise.
He appeared before division. He was very well there. He was speaking properly also. There was no difficulty. Yes, Mr. Jha.
My lord.
What is this matter about?
My lord, it is absent without leave, my lord. That's it. The dismissal from service, my lord, due to absent without leave.
Worst day of leave.
My lord.
That is what exactly happens.
My lord. That's 305 days, my lord.
When do you want it?
Lordship, after 2 weeks, Lordship.
Any objection? These are all 2000. What relief you will get now? See,
my lord, it's a procedure irregularities has been done. I have a citation, my lord, that entire receipts I have got that, my lord. He has to be reinstated in service, my lord.
Why it is pending from 2016?
My lord, they were.
Why should this kind of matter be dragged for so long?
My lord, we will argue on the next day. We will finish because we have that authorities, my lord. Misconducts cannot be per se misconduct, my lord.
Just write on the request made on behalf of the respondent. List this matter after 2 weeks. Nothing remains in the hearing perhaps.
Highly obliged.
Supplementary list. Item number 1.
This display doesn't work, this board.
May it please you, Lordship. Lordship, this is an application for condonation of delay in preferring criminal appeal. The appellant has been convicted for 7 years.
Delay of 1369 days.
My lord, the effective number of days is 490 days. And I have shown
Because of the
sufficient cause.
those.
My lord, it was earlier entrusted to another legal aid counsel, but due to the COVID and other unavoidable circumstances, the matter
Yes,
could
whether
not
state wants to object to that thing, condemnation.
No. Legal aid counsel, no.
endorsed to me on 11th of July, and I had sent it for signatures on 10th of August. But the accused, I have been informed, was in hospital. That is why there was a delay.
It's all right. It's all right. If they are not objecting criminal appeal, normally delay is condoned. Okay, hard please. London Legal Aid Council. Or the applicant. This is an application of delay. You see, there is it seems like there is a difference between the calculation of period of delay by you and the office note. The office note says it is total delay of 1309. Your petition says 1279.
My lord, I have calculated month-wise equally 28, 30, 31. That way I have added completely. The judgment was passed on 3/1/2020. After that, day-wise I have calculated, my lord. Right from 2020 till 2023.
No, what happens if there is a difference? You can say that the period which has been shown to the office has not been explained in your petition. That is what the problem is.
No, no, this was not informed also. My lord, may take into consideration any one of these as your lordship.
That is the difficulty, you know. You see, like if your petition says something,
But my
you
lord,
can understand.
I have calculated
See,
day by day.
for condoning,
My lord.
the same ground would be accepted. It is,
My lord, my lord.
okay, since the state is not making any objection.
Yes, my lord.
Only thing is that when it comes to recording the order, then what should be recorded? That is the main thing. That is the difficulty. Any for condonation of delay of 1279 days, comma, give a cap, which according to the calculation made by the registry is 1309 days. Stop. At the outset, Mr. K. Khan, Lord AG, submitted that the state has no objection for condonation of period of delay. Stop. Only because there is a delay in ending, that can it become a acceptable ground?
My lord, COVID also I have mentioned. From 15th of March 2020 till 30th of May 2020.
Then why you have given 1 to 7, 9 days?
My lord, because earlier also I had preferred one writ appeal and I had given in the certificate that there is no delay because the Supreme Court has excluded in the computation itself. But the registry does not accept it. It says that no, you have to file a separate application for condonation of delay. And it even came before the Honorable Division Bench, and the Honorable Chief Justice had said that you have to file an application for condonation of delay.
Okay. Just read my small order. The reasons for delay explained in the petition, explained in the application for condonation are found to be good reasons. Stop. According the period of delay in preferring the accompanying appeal is condoned. Application stands disposed of. The application stands allowed and disposed of. If you go into the whole thing, the thing will become more difficult. Yes, in the appeal. Where is that? Admit the appeal.
Statutory appeal, LCR may be called.
Yes, it has to be. Okay, hard. So for the appellant, admit this appeal. Call for the lower court record.
Lord, there is one prayer, my lord. I have filed one miscellaneous application.
Just wait. Let me complete. Pass this. Then just wait. Call for the record. Mr. K. Khan, non-DHG, appears for the respondent, isn't it? There is no other private respondent?
No other private respondent.
Yes, there is only one respondent.
Yes, my lord.
Yes, list after this. List this matter after receipt of the lower court record.
Lord, one prayer. I have filed another miscase, my lord, under section 389(1) for suspension of sentence. My lord, the reason
you have preferred an application.
My lord may consider it on a later date, but my only apprehension is, my lord, that the accused date of release is November 2024, my lord. He has already undergone 6 years of imprisonment out of 7 years.
What to do? If you are late in approaching the court, who can we blame for that?
Agreed, my lord, but
this is your own action.
my lord, it was these are
criminal appeal paperwork has to be prepared. Even if your application under 389 is to be considered, then we have to embark upon merit of the matter. So why to do this? Rather than, I think, once the LCR comes,
my lord, we'll
first
try
to
our
office,
best to
prepare the paperwork faster, then we can finish it faster. That will do. List this matter after. Yes, that's okay. We'll just take it. Let the answer come and then ensure that paperwork is prepared for.
My lord, I'll try to pursue with the registry. The registry will be preparing the paper book in this matter.
Main list, item number 1.
May I please, Your Lordship?
Yes.
My Lord, as regards to respondent number 4, I have verified and have taken steps, my Lord. And the service is complete, my Lord.
Yes, anyone appearing for respondent?
This is Your Lordship. We have the instruction to appear for all. I have the instruction to appear for all.
All the. Yes.
Then, my Lord, let it come for hearing final disposal after 2 weeks, my Lord.
Will be filing a response? No, you don't want to file a response.
No, Your Lordship, this is
it's up to you.
Question of law.
It's up to you, whatever it is. Anyway, the learned counsels for the party submits that service of notice upon all the respondent is complete, and they are being represented in the court. by their respective counsels. The parties also submit that the matter is ready for hearing. All those cases. And praise that separately. The same may be listed for hearing after 2 weeks.
2 weeks, my lord. Obliged.
List.
Obliged, your lordship.
Hearing item number 16.
May it please your lordship, in this matter the petitioners were directed to file an additional affidavit or a petition bringing on record the FIR,
yes,
of which they are seeking quashing, but that has not yet been filed, my lord.
We were asked to produce, my lord. I have the.
Your lord to bring it on.
On the 25th of
Yes, yes. No,
September,
we have-
it has been said that Mr. Day, Learned Counsel, petitioner submits that a copy of the FIR has not been received
for
by-
filing before
this court.
So you have
And
to
raise
bring
for
it-
grant of
I
some
have
more
the copy.
time.
I have the copy. If
Bring
required,
it to
you can
record,
file
you
it by
see.
affidavit. Otherwise, I can produce it today, my lord, if lordship.
No, producing means if you are seeking quashing of it, then it has to be part
It
of
has
it.
to be brought
I'll
properly
put
on
an affidavit.
record.
Yes, it is being into records. This 5-9 also
We'll
it
file
says.
a lordship. Yes.
Then
File it, yes. We'll file an affidavit.
okay, Mr. S. Day, Learned Counsel for the petitioner, submits that a copy of the FIR in question has been supplied to him, has been received by him.
Lordship. This is the suo motu FIR. There are 2 FIRs.
One you have already made part of it, isn't it? So we are just saying FIR in question because there is not much identification of the same in the records. Once it comes to you, you can distinguish whether that is the same one or it's a different one. Or what was order so and so has been received by him, and he prays that he prays for grant of some time for bringing it into the record by you of an affidavit.
Lordship, the next item is also
Similar matter, where I'm
similar.
appearing on
So
behalf
I
of
may
the
be allowed
state.
to file it
They are
in only
allowed?
one matter, Lordship.
When? How long?
1 week, Lordship.
They are allowed. List is matter after a week. Same order will be?
Same FIR.
Different petitioners, but
Same
the subject matter is the same.
So same order will suffice, or whether there is just
Let him file in both the cases, Your
that is all
Lordship.
right. We have to check the order. Let us.
The FIR is to be filed in both.
Here also you are paying for the
Yes, the petitioner.
It's the same FIR.
okay. The same order has been passed in the
We'll file it in both.
same order.
Last
I think that is the.
That was a
Obliged.